Started. Hello, and welcome to So a Neighbor Asked, a monthly series from Mountain States Legal Foundation, where our attorneys answer your questions to help you understand the Constitution, the law, and principles of liberty. I'm your host, Erin Erhardt, an attorney here at Mountain States. Before we begin, I wanted to tell everyone who we are at Mountain States Legal Foundation. MSLF is a nonprofit, public interest law firm dedicated to restoring the rights enshrined in the Constitution at zero cost to our clients. We're focused on protecting property rights, economic liberty, the right to keep and bear arms, free speech and association, and equality under the law. From our headquarters in beautiful Colorado, we litigate crucial cases across the country at every level, from the district courts all the way up to the Supreme Court, especially those that will make a difference in our country. And our Center to Keep and Bear Arms, our Second Amendment Center, is the only in-house litigation-only Second Amendment Center in the country. I'm joined today by my colleague Brian Abbas, the new director of Mountain States Legal Foundation's Center to Keep and Bear Arms. Joining us today is a familiar face to many, Cody Wisniewski, who is senior attorney for Constitutional Litigation at Firearms Policy Coalition. MSLF and FPC have worked together on, among other things, a very important case called VanDerStok v. Garland, which we'll talk about more in a little bit. And we're honored today to have one of our clients from that case on this webinar with us. Nick Cherry is a general manager at Tactical Machining. Tactical Machining is a retailer and producer of items for the home gunsmith and one of our plaintiffs, like I said, in the VanDerStok case. Nick, why don't you say hi and tell us a little bit about Tactical Machining?
Hey guys, we here at Tactical, we started in 2008 manufacturing the 80% for the AR-15 platform. Since then, we've got 4 other 80% that we've manufactured. And still going strong. So,
all right. Well, we're happy to have you with us today. So I'm going to ask a few questions to our panelists here, and then for our viewers online, after we chat here for about a half hour or so, we're going to have a question and answer session to close out this episode. If you're joining us on Zoom, you can find at the bottom a Q&A portal where you can submit your questions. And if you're watching on Facebook Live, we'll try our best to grab your questions from the comments. So let's get to it. Our topic today is, what is a firearm? So let's get into it. Guys, what is a firearm?
Well, if you guys don't mind, I'd like to start with Merriam-Webster's dictionary's definition of what a firearm is. Firearm is a noun, a weapon from which a shot is discharged by gunpowder, usually used of small arms. First known use was 1643. And then after that, well, I guess for legal purposes, we have the 1934 National Firearms Act, which states that a firearm is a shotgun having a barrel or barrels of less than 18 inches in length, and a weapon made from a shotgun if such weapon is modified for an overall length of less than 26 inches, or a barrel or barrels of less than 18 inches in length. A rifle having barrel or barrels of less than 16 inches of length. A weapon made from a rifle, such as weapon is modified, has an overall length of less than 26 inches, or a barrel or barrels of less than 16 inches in length, and the list goes on.
So that seems about as clear as mud, right?
Yeah, and that NFA definition, right? That's that old school 1930s, like post-mob era definition. And then so in 1968, and what comes up in the subject of this VanDerStok case, in 1968, Congress passes the Gun Control Act. And it's this idea to kind of remake federal firearms law in the United States. And they crafted this new definition of firearm, not only playing off what the NFA had done, but playing off what the prior Federal Firearms Act had done. And the definition of firearm that reigns in America today is a weapon, including a starter gun, that is designed to expel a projectile by the means of an explosion, designed to or readily converted to. So that's the first definition of firearm. And then the second subset is the frame or receiver of such weapon. Now, in the industry, I feel like we pretty much know what a firearm is. But of course, when you step into the regulatory space, magically now the federal government needs to set these very specific definitions. So
that's the main reason.
Oh,
That's the main reason why we're here today, is because of the definition of what a firearm is, based on the firearm frame or receiver from the ATF.
exactly. And so the idea behind this Gun Control Act passage, this amendment to the definition, was the federal government thought, we're going to regulate a thing. Now, that thing is either going to be a functioning or near functioning weapon. So like an actual rifle, an actual handgun that pull a trigger, bang, bullet shoots out the end, or a single piece on that weapon, whether it's the frame or receiver. This was to avoid the prior regulation, which seemingly regulated just about every part. So you could have a trigger was a firearm, a barrel was a firearm, which, those of you that are familiar with European regulation, the barrel is a lot more commonly regulated outside of the United States. But it was to avoid that kind of piecemeal and to have this very specific tie down to exactly what the agencies could or could not regulate.
And so for the longest time, we had the gun control after the Gun Control Act of 1968. The Treasury Department published their final regulation of what they considered a firearm frame or receiver. And for the longest time, it was defined as the part of a firearm which provides the housing for the hammer, bolt, or breech lock and firing mechanism, and which is usually threaded in its forward portion to receive the barrel. And so that definition essentially remained the standard definition of what a firearm frame or receiver was for about 50 years, until recently the ATF decided to change their mind and change the law.
And that gets us into the regulatory scheme a little bit. As I'm sure everyone on this webinar knows, we have an entire federal agency devoted just to guns, and tobacco and explosives, called the Bureau of Alcohol, Tobacco, Firearms, and Explosives, or the ATF. Not to mention every other bureau and department and administration that touches these issues as well. Brian mentioned the Treasury Department a second ago. Originally, this stuff was kind of housed under the control of the Treasury Department because it was basically a tax scheme, but it's been expanded quite a bit since that time. And now it, like I said, has its own department. So how did we get to the point where guns are so regulated? What's the history behind this?
Well, I think we have a long, complicated history, as we said, starting with the 1934 NFA, which mostly just meant to regulate short-barreled rifles, short-barreled shotguns, machine guns, silencers. And then we had the Federal Firearms Act of 1938, which went in and defined firearm. And then we had the Gun Control Act of 1968, which went back and really tried to start restricting firearm ownership more. And then we had the 86 Firearm Owners Protection Act, which also restricted firearms a little bit, at least machine guns. So after the 86 Act, or the 68 Act, that's when the Treasury decided to publish the what is a firearm frame or receiver, because that wasn't clear for the longest time. And it was only really necessary after the 68 Gun Control Act, which started regulating firearm frames and receivers.
Is it clear now what a frame and receiver is? Because just earlier this year, and this is the topic of our VanDerStok case, the ATF for the first time since that regulation redefined what constitutes a frame and receiver in a 400-page plus final rule on frames and receivers. So has that helped? Has that clarified things? Cody's laughing.
Yeah, I think it's clear as mud right now. I think Nick could probably talk a little bit about too how clear it is to them. A manufacturer who is producing things that have never been considered to be frames or receivers, what it looks like now. But yeah, basically what you get is there's this pressure on the administration, and they're moving on the campaign trail to stop these so-called ghost guns, right? And that's this derisive term that's being applied to firearms that people self-manufacture. The self-manufacture of firearms is a practice that predates our country, predates the Constitution, predates the Second Amendment, predates the ATF by a long shot. It is a tale as old as time. If you have the right to defend yourself with a firearm, you also have the right to either acquire or make that firearm yourself. And that's a practice that is not regulated under the federal government, right? You have that right as long as you're not an otherwise prohibited person to self-make your own firearm. But the federal government, not leaving well enough alone and testing the bounds of its authority, has promulgated this new rule in a so-called attempt to regulate those items. And what they're really doing is they're taking that language, that framer-receiver definition that framer-receiver reference in the GCA, the Gun Control Act, and they're trying to expand that as far as they possibly can to allow them to get their fingers into more regulatory authority and their ability to regulate more and more items and push them through the federal system. And the ATF, since that definition was crafted, has tied it to very specific, like, mechanistic features on items, on whether or not they qualified as a framer receiver. And now, under this new definition, not only are they throwing that all to the wind, at one point, the definition literally says that the director may or may not decide anything's a framer receiver. But they're also starting to consider other things that will never be a part of a firearm, like a jig, like tactical machining cells, that helps people self-manufacture. So it's definitely
I think we should,
nice and clear.
And I think we should clarify that when you said the federal government, it's not Congress and the legislature that's actually passing this. It is the ATF is doing it on their own as a federal bureaucracy. They're just kind of making up the law as they're going.
That's a really good point. The Gun Control Act, which has that federal definition of firearm that Cody read to us earlier, has not changed since 1968. All of this new stuff is solely coming out of the executive agencies under the Biden administration. It's not coming out of well-reasoned congressional action, for lack of a better term. And I think perhaps my favorite part of the final rule, or one of the craziest parts of the final rule, is that the definitions are so broad that it even says that the definition doesn't go so far, it specifically excludes unformed blocks of metal that could become guns, because otherwise the language is so broad that just a chunk of metal could be regulated by the ATF, which clearly Congress never gave them the power to go that far. All right, let's hear from Nick a little bit about these new regulations and what he's seeing on the ground and how things have changed for them.
Yeah, well, for us, I've been here since 2012, and for every 80 we've manufactured, we've got a determination letter from them saying that it's not a firearm. Those got thrown out the day this new rule went into effect. I had to resubmit. I resubmitted in April, the day after they talked about doing it. They never gave me a letter holding it over our heads. Because of that, we ended up not selling jigs for the longest time. Because if I sell a jig with a 80 now, it magically becomes a firearm, even though it's still just a hunk of metal with no definitive markings on it or anything like that. But this new rule made it almost impossible for us to exist as a business.
And would you tell us a little bit about those determination letters?
Yeah, those determination letters were basically, we would submit a part to the ATF, and then they would respond with if it was or wasn't a firearm. One of the versions we had submitted, they kicked back and said that because we cut too far into the fire control group pocket, it was determined it was a firearm, and we needed to move that pocket out of the actual fire control group spot and just allow an upper, where the upper would go is as far as it can go in. And then, so we moved it and then got a determination letter saying that it was in fact not a firearm now, just because we moved it back about 10,000ths of an inch. So like 3 hairs.
Wow. So you've been working with firearms and firearms parts for a long time. Presumably, you should be able to read these rules and know what's a firearm, right?
Yeah, up until recently, it was very defined, and now it's so convoluted. It's readily manufactured is a term they like to use. Well, what's readily manufacturable? I mean, I know that these aren't readily manufacturable, but they're claiming they are, and I will challenge anyone to come here, and I'll give you everything you need. Please put it together. Like, you're not doing it, especially you're not your first one without any instruction, and we've never provided any of that or anything like that. So it's just the narrative that they're portraying is just so false. It's not even close.
Right, and that's part of the reason we brought this suit, VanDerStok v. Garland, and it may be confusing if you're not familiar with this case on why it's called VanDerStok when we're talking to a gentleman named Nick at Tactical Machining. We also have a couple other plaintiffs in this case, including Jennifer VanDerStok, a lady in Texas, and Mike Andren, a gentleman in Texas, who are our individual plaintiffs in the case, as well as Tactical Machining, our business plaintiff. They're based in Florida. And Nick, why don't you tell us why you got involved in the lawsuit?
Because this ruling is just it goes against everything we stand for, especially down here. Like we were big proprietor of making your own, building your own. Like I said, we've been around since 2008, and this has been our I think 92% of our business is 80%. Like there isn't. We do have hundreds and all that, but our customer base doesn't want that. Our customer base is the average Joe in their garage that just enjoys the hobby. That is, do it yourself. Anything really. That's pretty much the type of people we're going after. The ones that like to just do it all. It's just been tough. Since they put out the ruling, even beforehand, they're throwing jigs into the definition. We thought we were doing everything right by not selling them, and in actuality, I guess I could have sold them throughout the whole time, but the whole ruling was so convoluted, we didn't know what was going to happen. So we thought we made the right choice by not selling them. But sales and everything fall when you don't have like our customers need the jigs to finish them. They don't have CNC machines. They don't have, bridge ports. They have drill presses and routers. And that's how they manufacture. And without those jigs, it's almost impossible.
Nick, you said something about your customers that I think is really important to highlight here. And that's this whole treatment of 80% lowers of these items is part of this kind of like gun control language campaign, right? Where they're trying to paint these things as evil items that are used by bad people and criminals to avoid and exploit loopholes in federal law. But really what it is the vast majority of these people are just everyday, peaceable people who want to make their own self-defense tools, who want to learn more about how to manufacture a firearm, who want to better understand the process. Some of them, Mike Andren, one of our plaintiffs in this, is a good example, right? Somebody that was a literal aerospace engineer who worked on like the B-2 bomber, who wants to continue to flex that muscle and work with manufacturing and work with engineering. That's the people that are owning and buying these. These are not overwhelmingly chosen by criminals. Of course, those are the news stories that when it happens, they broadcast it as loud as possible. But these are just items that everyday people can buy and use to manufacture their own self-defense tools. And I think that's a really important point to reiterate.
Absolutely. And something we've said before is that when it comes down to it, manufacturing your own gun, buying the parts to manufacture your own gun is really no different than buying cloth and sewing your own clothes or buying seeds and growing your own garden. It's all about self-sufficiency and doing things for yourself. Just because things might be commercially available so that you don't have to do your own gardening and sewing and manufacturing doesn't mean that such things are inherently sinister or should be criminalized.
And let's be clear, there is no actual legal definition of what is an 80% firearm and what isn't an 80% firearm. According to the ATF, things are either they are firearms or they aren't firearms. So there's no clear definition there. And Nick, do you have any idea how long 80% receivers have been available to the general public?
I know that when we got into it in 2008, there were a handful of companies doing it. They weren't taking the flashings off forgings and things like that, and it was mostly a forum-based business. If you had to be on these forums to even know they existed and to get them, and that's how that's how we came about. My boss wanted to get his own made, and he was told he needed to make get 5,000. And he's like, well, I'll just do it myself. And he bought a machine, hired a machinist, and the rest is history. Because we're here now, 13, 14, 15 years later now. So, it wasn't really an industry back when we started. We were definitely one of the first ones to bring it commercial.
And the
And
practice surrounding it too predates the AR style unmanufactured or 80% lowers. Right, the practice dates back to at least the 60s, where there were kits floating around for a lot of firearms that weren't necessarily easily available in the United States. You see this come up with AK flats, where people are able to fold up their own trunnion and create their own AK. This is something that, I mean, the tools to manufacture a firearm have existed since people started manufacturing firearms. It's just those tools and those materials that are available have shifted with markets and have shifted with availability. This isn't new or earth shattering. It's just the next step in the process. And what you see, like with tactical machining entering the space so early, really developing a market share and helping this market really develop. What tactical machining has done, and what the 80% lower industry has done in America, is not arm bad people or help that process. What the 80% lower industry has done in America is help more Americans arm themselves and help more individuals and peaceable people in the United States learn about firearms. And that's what this industry is. It is nothing else.
Yeah. Well, I think the industry's always definitely been there. And it's not just about 80% receivers. It's about the right to build your own firearms in your own home in general. I mean, if we look at a lot of the, most novel innovations in the firearms industry, it was made by people in their garages or in their machine shops back at home. John Grand with the M1 Grand back in the day, Eugene Stoner with the AR-15 and AR-10. And even if you look at some of the calls that the U.S. government did for inventors to actually come and provide samples of like semi-automatic firearms, when the U.S. government was looking at switching from single shot or from bolt action rifles, I should say, not single shot, but like the bolt action Springfield to semi-automatic rifles. Even back then, you had a whole slew of home builders that in their shops, they actually got some 03 Springfields from the government for free or for really cheap to actually be able to go through and try to modify them to actually be semi-automatic rifles. And this is just something that's really has a strong history and tradition in the United States that a lot of people don't know about.
I think building things in garages in general has a big tradition in the United States, whether it's home gunsmiths or Apple or Microsoft. We have a history of innovation in garages in this country.
And this goes back to our founding. I mean, that practice started, in 1777, the Continental Congress called on Joseph Belton, who had created a semi-automatic firearm that could fire 16 shots without reloading. And he claimed he could fire up to 20. And they made a huge order for those. I mean, the practice of civilian innovation in firearms is literally why we have a country, let alone why we've protected the right to be able to bear those arms and manufacture those arms.
And to bring it back to basics real quick, since you just mentioned semi-automatic firearms, we've heard a lot from the administration about banning assault weapons. The other day, President Biden said something about perhaps banning semi-automatic firearms. Would one of you just like to explain to us real briefly, what is the difference between an automatic firearm, a semi-automatic firearm, et cetera?
So you pull essentially semi-automatic is you pull the trigger once, it goes boom once. Fully automatic is you pull the trigger and hold it down and it keeps firing.
Great. And semi-automatic automatically reloads. That's where the automatic comes in.
Correct.
And the definition assault weapon has no meaning, right? I mean, This is something that's thrown around by different governments, different cities. They try and define it their way. Essentially, it's a semi-automatic. The easiest way that I've figured out how to define a so-called assault weapon is a semi-automatic firearm that has features that they don't like. So
it looks scary, right?
Yeah. So if you have the wrong stock on it, if you have the wrong grip on it, if you have a foregrip when you should have an angled foregrip,
it's too many bullets.
Yeah. Your magazine takes too many rounds. It's too easy to protect your own life. Those are the kinds of things that land you into that territory. But it's not a federally defined term. It's not, and it doesn't really bear any meaning on the function of the firearm itself either.
There's no clear consistency, as you said, between different jurisdictions of what each jurisdiction would consider, this is an assault weapon, and in every single jurisdiction. It's kind of like 80% receiver. It's a kind of a legal fiction. It either is a receiver or it's not a receiver.
Right. Cody, why don't you tell us a little bit about what we're fighting in the VanDerStok case and what our end goal is.
Absolutely. So this rule that we've kind of talked about a little bit that Nick mentioned that went into effect in August, this was a rulemaking that was created by the agencies. So the Department of Justice and ATF worked together on federal firearms regulations. So the agencies got together and crafted this rule in order to further the agency's regulatory reach, essentially. And that's a long way of saying that the executive branch decided that it wanted to regulate things that Congress hasn't really said that it can regulate, and they're going to find a way to do it. And that's what they did in this rule. So they took those definitions in the Gun Control Act and they said, well, frame or receiver isn't defined in the Gun Control Act. We defined it in the 70s, which was the definition that Brian read earlier. And that doesn't really fit with modern technology. So we're going to redefine it. But in redefining frame or receiver, they have expanded their authority to regulate a bunch of items, like those things that tactical machining makes, that the ATF and Department of Justice have never regulated in the past, and in fact have authoritatively said in court filings that they didn't have the authority to regulate in the past. So this rule is incredibly broad. Now, when you challenge an agency rulemaking, a final rule, you do so under the Administrative Procedure Act, which is a federal statute that allows people who are harmed by federal agency rulemakings to bring those challenges to federal court, which is exactly what we did. And so our case aims at a lot of different issues with the final rule, including that question of how far the agency's authority reaches here or how far it doesn't reach, and several other problems with the rule. Now, we filed in August. We immediately moved for a preliminary injunction in the case. A preliminary injunction is basically a request that the court stops the government from being able to enforce the rule while the case goes on. So it kind of just maintains the status quo and puts a big pause, kind of pumps the brakes. In a huge win, we were really excited to be able to get that preliminary injunction and then expand that preliminary injunction so that it covered not only our individual plaintiffs in the case and covered Tactical Machining's ability to sell the items that it's always sold, but also protected Tactical Machining's customers' ability to buy those items, so long as they weren't already prohibited persons who are already prohibited under federal law from owning actual firearms. So that preliminary injunction was huge. Of course, the federal government, not leaving well enough alone, has decided to appeal that injunction. That's going up to the Fifth Circuit since we're down in Texas. And so that briefing will be ongoing, but the injunction is still in place and is currently active. And then in the case itself, we are not happy to just sit and wait. So we're moving very quickly on our merits briefing as well. So we're going after the full entirety of the rule and a full ruling from the court instead of just that preliminary ruling. So we've taken some time out of our busy briefing schedule to be with you today. We actually have a brief due on Monday that will be addressing the scope of the agency's authority in this case. And then we've got another brief due just before Christmas that will address several other claims. And so those are going to be proceeding also. So lots going on in the case, a lot of background on it. And of course, if people have questions, feel free to ask, but that's kind of the 10,000 foot view with some explanations.
Perfect. Thank you. And before we move into audience questions, I'm going to ask one more question, but don't forget to get your questions submitted either through the Zoom Q&A portal or the Facebook comments if you have questions for us. Since we were just talking about our case in the courts, let's talk a little bit more about how the courts play into this. We obviously saw some major developments in Second Amendment jurisprudence at the end of last year's Supreme Court term with the Bruin decision. What does regulation and kind of the framework right now look like with the courts involved? And I know FPC's got several wins so far. How about we talk about how the standards have changed with the new?
Well, this kind of turned everything on its heads, right? I mean, prior to this, the Supreme Court's been really dodgy as far as Second Amendment cases and actually affirming the Second Amendment in general. I mean, we had the Heller case and McDonald, and this is just kind of a big win for for everybody that enjoys the Second Amendment, whether you're an industry professional or an avid shooter.
Yeah, absolutely. I mean, the Bruin decision that came down earlier this year basically took what the Supreme Court was trying to say in Heller, which was from 2008, and basically just said, we mean it. since Heller, since 2008, courts had been essentially ignoring Supreme Court precedent, and they'd been employing this two-step test to evaluate Second Amendment challenges, where they determined if something in the first step was protected by the Second Amendment or whether it was within its core protections. Core was made up, didn't come from a Supreme Court case, certainly doesn't come from the Second Amendment. And then depending on whether it was protected and if it was core or ancillary, they would apply a different form of means and scrutiny, which means they would balance the regulation. They'd balance your loss of rights against the government's real need to trample on your rights. And depending on how they came out, that's who would win. Of course, in a lot of these contexts, as soon as you balance with federal power or state power, the federal government wins or the state wins. So it's kind of a death spell for a lot of these issues. But in Bruen, the Supreme Court reiterated that when evaluating Second Amendment challenges, the test is the text of the Second Amendment as informed by history. It is the original public meaning of the Second Amendment as it was understood when those words were written and ratified. And so that is the ultimate guidance. And under that test, Erin, you're right. We at FPC have had a lot of victories under this kind of Bruen standard that's supposed to have been the standard all along. So we won another case in Texas, setting aside Texas's ban on 18 to 20-year-olds being able to carry firearms in public. So Texas inexplicably prohibited 18 to 20-year-old adults from being able to carry firearms, even like to get a permit to carry firearms concealed in public. So we were able to get a victory over that. That ruling was stayed and is up on appeal in the Fifth Circuit, but that was a huge win. We've had a win in Delaware related to these self-manufactured arms. Delaware tried to ban self-manufactured firearms and tried to force everybody to push them through a serialization process. So we were able to get a win there. We've gotten a couple wins in New York related to New York's Bruen response bill. Once New York's carry regulation was handed down, was set aside by the Supreme Court, they passed a new one that requires you to disclose your social media accounts, get 4 references, do 18 hours of training, 16 hours in person in classroom, 2 hours of live fire. And then once you have a permit, prohibits you from carrying in sensitive places, which include public parks, public transit, places of worship, and every private business in New York, unless they explicitly say you can carry there. So FPC's gotten a win on that provision, striking it down, saying that it's the other way, that you can assume if you have a permit, you could carry on a private business unless they say otherwise. And we've successfully gotten an injunction against the places of worship ban to ensure that people can protect themselves and their congregations when they're practicing their religion. So Bruen has been huge. It has been an incredibly important decision to come out of the Supreme Court, and we're seeing wins left, right, and center. Like I said, everywhere from Texas to New York. So whether jurisdictions tend to be favorable to guns or not, we're moving the ball in the right direction.
Yeah, and I think to be clear, there's still plenty more wins to be had too. I mean, there's a lot of new states that are passing new laws that really go against Bruen, but they don't care. They're still going to pass them anyways. So there's still a long fight on our hands ahead of us.
Absolutely. Right here in Colorado, it feels like every city and county is trying to put in more gun bans and in more and more creative ways to try and get around the new Bruen standards. All right, that gives us a great segue into some of our audience questions. And this first one's a little long, from David in Colorado. Is the underlying constitutional problem the prohibition on DIY guns, or is it the second order effects on the practical ability to keep and bear arms? If the ATF compromised and agreed to replace every DIY firearm seized with a top-of-the-line equivalent, would that be unconstitutional? Could the government get away with arguing it has a compelling interest in ensuring its citizens are well-regulated, or citizens' arms are well-regulated?
I think every citizen has the right to build their own firearm in their home. I mean, quite frankly, if you're not a prohibited possessor, you have the right to get an 80% receiver and then, I guess find a way to turn that into 100% receiver, which, as we've heard from Nick, is not easy to do. But it is fun to do, even if it takes you a week or a month. And I think everybody has that individual right to not only have a firearm, but to have a firearm that they've built on their own that the government can't trace.
And I'll pitch in a little bit on that one. I think it kind of goes to both the prohibition on DIY guns and also the other effects on the ability to keep and bear arms. Because after Bruin, they're trying to chip away at other ways to do that. A lot of states are instituting, for instance, magazine capacity bans. We have a case that we, in the state of Washington, challenging their 10-round magazine limit. These limits are arbitrary. It's a large capacity magazine limit, but a 10-round magazine comes standard with many guns. And Washington says 10 rounds, that's large capacity. That's what we need to ban. Colorado says 15 rounds is what makes it high capacity and needs to be banned. So a lot of it does come down to, even if you can get the gun, they're limiting your ability to use it. And criminals aren't following the laws. So let's put in these limits that make it more difficult for law-abiding citizens to limit guns. So that's something that we're fighting on our end as well.
Yeah, and that Sullivan case up in Washington, we're working with FPC and Mountain States are working together on that case also. That's a really important one to kind of really stop the flow moving forward. Here's your interesting fun fact for joining the webinar. One of the things that the federal government does have the power to do when it comes to firearms is actually to arm people in the United States. So Article 1, Section 8, Clause 16 empowers the federal government to arm the militias. And of course, the militias are comprised of, currently under federal law, I think it's every able-bodied man under, original Militia Act was 17 to 40. It's been expanded. So technically, Congress could pass a law arming individuals across the United States. I think that would be, just a brilliant idea. If I were, of course, sarcastically, but really the brunt here, right, isn't the idea that the federal is, can they prohibit DIY? Can they stop the tools? The ATF is an executive agency, right? The Department of Justice is an executive agency. They're not Congress. They don't have the power to unilaterally expand their reach. If Congress said that the ATF could regulate these items, that's a whole different question. And we would be in court dealing with that question and the constitutional authority that Congress may or may not have in that question. But we're not even there. We're a whole step removed of that. We have an agency that's going well outside its authorizing statute, that's flying outside the bounds of what it's done for the past decades, that companies like Tactical Machining have relied on, that everyday people have relied on in order to engage in this practice. It is certainly obvious that the right to self-manufacture your own firearms is protected by the Second Amendment. It is certainly obvious that the right to keep and bear those arms is protected by the Second Amendment. And it is just as certainly right that the agencies in this case have no authority to regulate what they're trying to regulate.
And that's a really good distinction to bring up, Cody, that I don't think we've mentioned yet. In our VanDerStok case, we actually didn't bring a straight Second Amendment claim, because this is all about the agency action and the agency overreach. So we challenged it, like Cody explained earlier, under the Administrative Procedures Act and under constitutional provisions like the separation of powers, not under the Second Amendment. We're not, because this is all about what the agencies don't have the power to do. If Congress tried to do something like this, maybe we'd then challenge it under the Second Amendment that Congress went too far, but that's kind of a different ballgame. All right, let's go to another question from Will in Colorado. Are self-manufactured guns used in criminal activities in major cities? Could that violence be somehow used to justify and limit self-manufactured guns? That does seem to be the rationale that the government uses when they try to do this. So are they factual when they're doing that?
I mean, no. Are they ever used? Sure. Are they commonly used or even regularly used? No. If you look at like a city like Denver, for example, I believe that in Denver, firearms recovered at crime scenes, there were 2% or less than 2% that were self-manufactured. And that's not even just from like an 80% lower for like an AR platform. That's including everything, whether it's for, a handgun or something else. It's a minuscule percentage. You're not seeing the overwhelmingly firearms that are used in crime are firearms that are bought on the black market illicitly. I mean, that's again, a tale as old as time. And even if they were, it doesn't matter because the agency lacks the authority here, and the federal law is clear. I mean, the Gun Control Act is clear. These things are not regulated as firearms under federal law. And if Congress wants to change that, that's up to Congress, and we can deal with that when that happens. But no, they're not. And even if they were, it wouldn't matter.
Well, and I think, it also kind of comes down to what do we consider a crime scene? Because, I mean, for law enforcement, anything can really be considered a crime scene. Like if a firearm turns up at somebody's home, during the course of some other investigation, whether like the person has drugs in the home, even if it's for personal possession and there's a firearm in the home, oh, well, a firearm is turned up in that home. Also, if somebody's a prohibited possessor and they get popped for, for being a prohibited possessor, oh, a firearm is turned up at that crime scene. And so I think, the numbers are skewed in a way that a lot of these firearms are taken away from people. Sometimes people are criminals, but the vast majority of firearms that are used in crimes tend to be stolen firearms a lot of times because, or sometimes we even have criminals that have gone through and gotten the background checks to actually go and purchase a firearm legally. It's just that they've never been caught. I used to be a prosecutor and I've seen all sorts of things. As far as 80% receivers turning up at crime scenes, that is pretty rare.
Yeah, I think everything I've read tracks with what Cody said. Something like 1 to 3% of the guns recovered in crimes tend to be these 80%ers and these self-made guns. So a very small percentage of the guns that are actually recovered. And I'm going to kick this next question to Brian first, from Jerome in Tennessee. Is the ATF even constitutional? Why is Congress able to regulate guns when the Second Amendment protects our rights?
Well, if we're going off of my personal beliefs, I completely disagree with the ATF. I don't think it's constitutional to me. I believe the Second Amendment should trump everything. And I don't think Congress has a right, absent of actually repealing the Second Amendment through another constitutional amendment procedure. I don't think Congress has the right to really limit the ability of the individual to own firearms.
Yeah, just to agree with Brian, the ATF is certainly unconstitutional, and beyond that, it's a weapon that's used by the federal government and wielded against people. It is more commonly going after peaceable people, everyday individuals. We're seeing federal firearms licensees, the people that have to be licensed by the federal government to sell firearms. We're seeing them lose their licenses under this administration for minor discrepancies in their bookkeeping. If they have a typo, if they miswrote something, they're revoking their licenses. You see the ATF going after peaceable people, doing investigations, spot checks if you buy too many firearms in a short period of time, according to them. I mean, it's very clear that they are usurping any authority that they may even claim to be granted by Congress. And even that is certainly illegitimate. The ATF, Erin, like you mentioned, started as a revenue collecting agency, right? The NFA was a tax. Machine guns aren't banned in the United States. They're heavily regulated. They're heavily taxed. Yeah, Nick's right. It's a lot of money. So you got
money, you can have them. That's it.
Yeah. You have to find one, first of all. That's going to cost you 10 grand right there. And then you have to apply for a federal tax stamp. It was a revenue collecting group. That $200 tax stamp was the average price of a machine gun when the NFA was passed. The Tommy gun was really common, was $20, and you had to buy a $200 tax stamp to get that. It's the only tax in the United States that has never been raised since it was passed. It's also the only tax in the United States that doesn't fund the program that employs it. So there are there are massive problems when you come down to the ATF's claimed authority.
I like to call them the fun police.
That's fair.
Unfortunately, they're the fun police that show up at your door with 10 armed agents and then confiscate everything and make you a felon.
And don't even know what a gun is. They're just insane.
Yeah.
And
And,
can't even define a firearm.
yeah, even when I was a prosecutor right on the border, I mean, I was just kind of shocked at some of the individual citizens that I would see ATF agents actively going after versus actually trying to go after firearms traffickers.
Yeah, Nick, you deal with the ATF a lot. Cody mentioned the federal firearms license. A lot of the stuff that is at issue in the VanDerStok suit is stuff that was not and never has been regulated and shouldn't be regulated. So you could sell that stuff without background checks and without an FFL, but you do have an FFL and sell some items under that. Can you talk a little bit about other than the classification letters that you already mentioned about what it's like to deal with the ATF?
Yeah, it's not fun. We deal with so they'll call us randomly when they want us to do a trace because we manufacture. So they'll call us. Well, when they're investigating somebody or a gun was used in a crime, they'll ask us who had it, where did it come from, that sort of thing. They go right to the manufacturer. Then you got to go because we got to keep everything from the day we made it to the day it leaves here. The 4473s we got to keep, which is the 4473s are the paperwork you fill out when you go into a gun shop, and I have to keep every one I've ever done for however long we exist, and but that's the only way they can track all of these things is through that, and just other things like you were saying, the regulatory things. I heard people are getting shut down for, like you said, typos, easily explainable miscues that shouldn't warrant losing your license over, but they're just shutting everybody down. I have some choice words for them, but
we'll leave those for when we're offline.
Yeah.
And I think once again, I think sometimes when you're getting them traced back to you, it's not necessarily that they were used in a crime. It's just that they may have turned up at a crime scene, or the person that did have a firearm is no longer allowed to have firearms, and so they could be trying
there's no comprehensive list of all the guns that were manufactured ever. So they get one, they have a serial number, they have the manufacturer, they contact those people. And that's how they start tracing it. That's why it's called a trace. It's how they start figuring out where it came from and all that. Like I said, it's much easier to steal guns as far as I'm concerned than to make them. So I don't know.
It's a lot of effort, right, to make a gun.
If
you're already inclined to criminal activity, you might as well just steal one.
Right. If you're already involved in that sort of stuff, I mean, you're not listening to these rules anyway. These laws don't apply to you anyway. You're doing whatever you want. So these laws don't hinder those people. These laws hinder law-abiding citizens. These laws hinder the average Joe that just wants to. I get still phone calls every day. Can I own this? If you buy it from us, you can. If not, you got to buy them separate. Like it's absolutely insane. I got people buying jigs, which you're allowed to just buy a jig without a lower. They don't want me to send a receipt in the box because they don't want anybody to know they have it. And I'm like, well, it's not illegal. Like I don't know. Okay, whatever you want, sir. Like, but wow. It's every day. And it's because they're so vague in these rulings or these laws, or not even laws, these rules that they want to try to enact. I mean, you've never been able to regulate a trigger. Why aren't you going after those? Like, I don't understand it. It makes no sense why they think they have the authority to go after anything that's not a firearm. Like, that's what you regulate, firearms. so start regulating them.
Absolutely. All right, we've only got a few minutes left, so I'm going to ask two more questions. First, from Benjamin. So what can citizens do? Congress spends frivolous sessions on assault weapons bans, and we see all this kind of stuff happening instead of focusing on bigger issues. What, if anything, can just the average citizen do? Other than go buy stuff from Tactical Machine and make your own guns and exercise your rights.
Yeah. No, and I think, so for me, at least from what I've seen, I think one thing that your average person can do is, if your firearms are stolen, report them to the police as stolen. That way they can, track them down. I think that's the biggest thing. At last I heard, for figures, I think there's like about 1 million firearms a year stolen or something like that. So it's a significant number that are stolen by criminals.
Yeah, I mean, there's a few things that people can do, right? So you can exercise your rights, like, buy firearms, make firearms, do those things, show that these things are important to daily life. One of the tests that the Supreme Court looks to now is whether these things are in common use. Something that's hugely important. So people just exercising their rights and continuing to understand the importance of firearms, the importance of self-defense, the importance of the check on government, the importance of being able to protect yourself from criminals, to be able to protect yourself from tyranny, to protect your family, to protect your communities. I mean, that further understanding is huge. Now, if you want to go beyond that, you can, of course, support lawsuits, support what we do. You can go to joinfpc.org. You can join our membership. You can, help us support litigation that way. You can also, I know, Mountain States is working with us in this case. They've been great. You can go to Mountain States website, support their work there too. All of those things will help in this fight. So whether it's, you deciding to better understand your rights and to exercise those rights, that's amazing. And that, at the end of the day, is why we do this, is so that people can exercise those rights and protect themselves. If you have the means and you really enjoy what we do and you like the work that we've been able to do, it's all funded by you guys. Whether it's FPC or Mountain States, it's all funded by you. So if, Nick Tactical Machining is able to do this because we have people who care. Our individual clients are able to do this because there's people who care and that are supporting this case. And so that's really huge for all of us.
Yeah, and following up on that, don't be afraid to step up and exercise your rights, and always take new people shooting, because you never know what kind of person has a little bit of fun at the range. Then next thing you know, they're building firearms with you. It's kind of a bonding experience, and be vocal about exercising your rights and stepping up whenever you can to really show everybody that you're a supporter of the Second Amendment.
Yeah, and reach out. Like Cody said, go to our website, go to their website. Even if you're not looking to be a plaintiff in a lawsuit, if you're seeing these issues, bring them to us. Go visit our case pages and let us know what you're seeing out there, because we can't see it all. We need people like you guys to reach out and tell us what we need to be looking at too. Congress is focused on the wrong things. The government is focused on the wrong things, but we hope that we're trying to focus on some of the right things. All right, I'm going to give one more question real quick before we close out. This is for any of you who'd like to answer this. If the ATF asked you, how would you define a firearm? What would you recommend them to make their definition?
Nothing is a firearm. I can own whatever I want. Thank you very much. Have a nice day.
Yeah. Come back with a warrant, maybe?
Yeah. Yeah. Nothing's a firearm. I'm with that one. I like that one.
Amazing. Yeah. Until you commit a crime, why do we need to have the government in our business?
Yep.
Yep.
All right. Well, this has been a great conversation, guys. Thank you. Thank all of you who are watching for joining us on this episode of So a Neighbor Asked. And thank you very much to Nick for being our special guest today. Within the week, we should have this webinar uploaded to our YouTube channel, to MSLF's YouTube channel, for future viewing. And in the meantime, be sure to keep up to date with the important work at our website, mslegal.org. And you can follow us on Twitter at MSLF, or on Instagram at Mountain States Legal, or find us on Facebook. Cody and Nick, Cody, you've kind of mentioned a little bit about your organization. Where can they find you guys?
Yeah, absolutely. Thanks for having me. Thank you, everybody, for joining. You can find more about Firearms Policy Coalition at firearmspolicy.org. We're on Twitter and Instagram as Gun Policy. You can also find us on Facebook. You can see more about the case. I talk about it all the time. I'm the Wizard of Laws with a Z on just about everything. And you'll see me yelling from the rafters about the ATF and about this case. So follow us, check it all out, and then show your support if you can.
And Nick, what about you guys?
We're on all social media. I know that our website's tacticalmachining.com, Facebook, it's Tactical Machining, and then I think Instagram's tactical_machining. So I appreciate you guys having me on today. It was a lot of fun.
Absolutely. Thank you, guys. Thanks again, everyone, for watching, and we'll see you next month.